Good evening, everyone. Thank you so much for joining us again for another Teachers in Animal Law webinar. Really excited to be here tonight with a great panel of folks and a really interesting topic. Before we get into the discussion tonight, I do want to give just a brief intro for myself and for the webinar. My name is Solomon Yera. I am a current 2L at Georgetown Law, and I did take an animal law practicum class before, half seminar and half externship, where I was lucky enough to be one of the few to work with Humane World for Animals. Um, Before we get into the panelist introductions, I just wanted to give a brief overview of this webinar series for you, just in case you're not familiar with it, and if you're not, welcome. The Animal Law program at GW Law has established the Animal Law Legal Education Initiative, which strives to incorporate animal law as a standalone discipline within the legal academy. So this webinar series is intended to support those efforts by creating opportunities for adjunct professors across the country, as well as students, to collaborate with one another. We also hope that to provide you with some academic resources and a support system that can help you accomplish your goals within your institution. These webinars are truly intended to be conversational and a place where we can all network. So to that end, please feel free to send questions in the chat, put on your camera if you feel comfortable and are able to do so, or feel free to unmute yourself at any point in time or use the raise hand function of Zoom, and we can have a discussion between all of us. I will also reserve about 5 to 10 minutes at the end to take some questions from everyone. To that, I encourage you to, if you have a question towards the end, we can definitely spend some time on it. But other than that, the last thing I wanted to mention, if you missed our previous webinars, the recordings of those are up on the GW Law website, so please feel free to check those out. And the event is being recorded and will be made available on the GW website as well. So if you'd like to reference it back to today's discussion, please feel free in doing so. And if you know anyone else that'd be interested in viewing these series, please feel free to send it their way as well. The final thing I will mention is that we have one more webinar in this series for the semester, very exciting, and that will be in March. So stay tuned. But for right now, we will move on into tonight's very exciting star panel. We will be discussing teaching law while it is changing, and we will turn it over to the panelists to give a brief introduction. I'll just go in order of who's on my screen. So first up is Professor Ralph Henry.
Hi, yeah, I'm Ralph. I'm a senior director of litigation at Humane World for Animals, and I've been with Humane World for Animals, formerly known as the Humane Society of the United States and its family of organizations, for about 18 years, I think, or so. Getting long enough that I can't remember the exact amount of time. And I have taught animal law in law schools for over 17 years, first and exclusively at George Mason University, and since then at other schools. I'm now at Georgetown Law. So that's me.
Great. Thank you so much, Professor. Next up, we'll have Professor Cheryl Leahy.
Hi, everybody. I am Cheryl Leahy. I am the director of the new Animal Law Practice Association at the Brooks Institute, which is meant to provide practical written resources and a networking opportunity for people who want to engage in animal law, engage in more animal law, sort of making it more a bigger and more impactful field. I also have my own animal law practice. I do some non-animal law as well. And I've taught beginning back in the day, I taught animals and agriculture and the law at UCLA. And my most recent course I taught was at Vermont last summer on undercover investigations, which is a topic that is close to my heart and I will never bore. If anyone ever wants to talk about investigations, I always am happy to talk about them.
Fantastic. Thank you so much. Then we will have Shelby Babosky.
Everybody, my name is Shelby Babaski. I am an attorney in Dallas, Texas. I've been practicing since 1999. For the past 15 years, I worked at a Texas nonprofit called the Texas Humane Legislation Network. Um, Recently just left there and excited for new opportunities coming my way. I have taught at Southern Methodist University, SMU, Dedman School of Law for I think it's now 9 years animal law and 5 years wildlife law. So I teach animal law in the fall and wildlife law in the spring. And I think I was one of maybe the original individuals that brought this topic up to Kathy and Ralph because I was really wanting to hear from all of the other experts. So I'm just honored to be on this panel and tell you guys what's somewhat working for me down in Texas, but I can't wait to hear from everybody else. Thank you.
Fantastic. Yeah, I'm really excited, but who knows what's going to come up. And lastly, we will have Isaac Wercham.
Hi, I'm a 3L at Georgetown University. Um, I took an animal protection practicum course last semester with Seoul, and I really enjoyed it. I came to law school with the intent to pursue a career in animal law, but I have not had many opportunities to engage in animal law. And so I have, some opinions I'd like to share this evening about starting and supporting animal law courses in law schools.
Great. Thank you so much, everyone, for introductions. And now we'll just jump right in. So to frame the subject just a little bit, in this panel, we'll be discussing teaching while the law is changing. There is quite a popular perception among many current law students and lawyers that the law is changing more rapidly lately and to a larger degree right now in comparison to any time in the last several decades. This creates challenges for both law students and for professors, and we intend to explore those in this panel. So just to set the scene, I want to start off very broadly. What are the changes to animal law? Are there any new court rulings, regulatory actions, or legislation affecting animals that anyone would like to discuss in particular?
I can jump in with some of my favorites, unless anyone else is dying to. So substantively, along with my bias toward investigations, I really like the cruelty laws. I think it's really interesting. We're faced with this situation where we have cruelty laws in every state. They're almost all exclusively criminal, can only be enforced by uh, law enforcement and prosecutors. They also often exempt standard practices. And even when we have really strong legal arguments, strong evidence, oftentimes the best we can do is, bring the evidence forward and hope the law enforcement takes it. And we are given sometimes the least logical reasons that they decide not to. And they could just say no, thank you, right? So I think what's really cool in terms of changing areas of the law, I think what's happened as, so if we want to put a nutshell on this problem, right, it's most of the cruelty is happening in places where it's least likely to be enforced, right? And that's a structural problem with the cruelty law. So we've had these two interesting branches kind of develop in the law out of necessity for this problem, right? So one is a creation of really interesting, creative, and successful litigation strategies that are basically indirect enforcement of the cruelty laws. So you're talking about things like false advertising, um, unfair business practices, taxpayer standing. Public nuisance, right? So you see this whole kind of area of law blossom around finding ways to put the cruelty in court without having to go through that. And then the other kind of branch that's happening is all of these procedural avenues to kind of jump over at least some phases in the process, or even have a full-blown civil enforcement or even criminal enforcement as a private party. So those would be like SPCAs or humane societies that can file charges, bring civil proceedings, seize animals, get into court criminally to seek judicial review, review an investigation. The process that the enforcement body does could be things like citizen access to grand juries, the citizen petitions sometimes there's a civil component in the cruelty law. And I think what's so cool about that is a lot of these laws, they're just already sitting on the books and we just haven't tried them. And when we start trying them, people start picking up more. So I think the lesson to be taken away from an example like this is check out what people are trying, right? Even if they're in early stages, what has worked, what has never been tried, why hasn't it been tried, right? And kind of start kind of generating ideas from that. I think that's a really um, kind of fun learning process and creative thinking process. Um, Other big area everybody, I'm sure somebody will mention this, is standing issue that's changing quite a bit, right? So everyone talks about, oh, we don't have Haven standing anymore after Alliance. Or we do, but it's very narrow and it's narrow in this specific way. The takeaway for me for that is we really should not be making assumptions just based on what somebody has opined on or guessed. I mean, even if it's an educated guess, right? I think the idea is to really look at, okay, well, now what? What is the story that led to this case and this ruling? And what's the history of havens and how does this fit into the broader landscape of standing, right? Like it's a starting point. It's not, oh, well, it's done. We need to move on. So yeah, those are my two favorite examples.
Lovely.
I appreciate that response, Cheryl, because it talks about, as you noted, sort of at the end of it, not only that the rapid changes in the law present sort of burdens on animal law practitioners, but new opportunities for us as well. And so it's, it's bad to make assumptions about how all of this new law, whether it's court-made law or the changing regulatory state, which is happening rapidly under the current administration, can seem like a lot for students and practitioners equally. And but there are opportunities presented in that. And so I think it's important that we address those. I mean, at a more granular level, Cheryl covered, expansions in the scope of criminal law to help protect animals and civil rights of action or civil remedies to prosecute what are traditionally violations of criminal law. I think so many of our human interactions with animals are governed by the administrative state. And I think students are very familiar, students who may take animal law, but maybe out of a bit of a curiosity. Maybe they don't intend to be animal law practitioners like Isaac, but they end up in our classes because they're just interested in the subject. I think they're very familiar with the idea that there's a bit of a significant effort by the federal judiciary, and especially at the Supreme Court level, to adjust the administrative state, its power relative to the judiciary and the executive. And there's a lot happening in that regard, and that affects animal law practitioners and animals a lot. And so I think we owe it to our students to think a bit about that. Cases like Loper Bright and Corner Post and remedies oriented cases affecting the administrative state like CASA and nationwide universal injunctions, those types of things. But I do think that we should focus on not only the degree and actual changes that are happening, but where they're coming from. I think that's kind of an important element too, to answer the question of sort of where are the changes that we should focus on. I think it's important for students to understand, because good practitioners of animal law, especially in mission-focused, policy change-oriented settings, are paying attention to this. I think it's important to focus on where the changes are coming. There's a lot happening in the federal judiciary now and in executive agencies. So while Congress might seem inert in some ways, and there are areas of law that are not changing so much, there's a lot for students to digest that are changing, and it does affect animals. And so, one area that I've tried to make adjustments to in what I teach in animal law is sort of the changing state of administrative law.
Anyone else for this question?
I will just jump in quickly and say kudos to all of those responses. And again, I'm learning so much. The Chevron deference being overturned in Loper Bright is hard because, you teach, especially through wildlife law, you look at the cases that you've brought up and taught in the past and said, okay, how can I look at this differently now? But from my perspective, from a policy 40,000 foot view, one thing I'm super excited and I don't know if anything's going to come from it, but recently in December, some of the current administration senior officials went ahead and said they're cracking down on animal cruelty. They want to roll out coordinated actions across the Justice Department. And, with USDA and HHS regarding animal testing, puppy mills, dog fighting. If I'm being honest, I've never seen that before in my lifetime. So that's super exciting. And how can we use that in our practice or in passing laws, especially in Texas? How can we use those statements and that attitude towards passing good animal protection laws that are not only effective, but hopefully will be enforced. And then also informing some of our legislators about our current administration's attitudes towards animals. So again, exciting news, not sure what's going to come of it, but at the very least, using those talking points in going in and trying to pass good common sense animal protection laws in your own state.
Yeah, that's all really, really insightful. And what I appreciate from all three answers is the emphasis on it's not just happening in one area. Right now, it's exploding in basically every area from policy to the Hill to common law and to SCOTUS, and everything in between is kind of moving quite rapidly. So, to that end, I think I want to shift to why and how a professor should adjust to these changes in the law. So, the first part of that question, the why do you think it's important to be mindful of the increasing changes to the law? Obviously, it is important, but how to address it in your teaching as well, and what approaches you take in your classes in order to do so effectively.
Well, I could start. I mean, I think in part it's important because the law is very alive for students. I think we all know this. If you're an adjunct, a law professor or thinking of getting into the game, it's very easy as practitioners to get focused on the types of things we do and to adjust as needed to various inputs to the types of things we work on. But the law is more alive for students at that stage in their legal career than maybe any other time. And so I think we owe it to them to be mindful of the degree of changes in the law, how rapidly they're occurring, and to address them. I also think that students could be frustrated, worried. They could be curious and excited about the fact that there's a lot of change in the law happening now. And, even if we maybe aren't in those same shoes as teachers or practitioners, we should put ourselves in those shoes as much as possible and recognize that's something students are going through, sort of experiencing the change in the law, what it means for them in practice. I sometimes dabble in following social media posts of students. I'm way too old and fuddy-duddy to participate, but I'm a lurker, like a fly on the wall. And I see the sort of consternation over like, what is the legal field going to look like for me, and try to think about that in terms of how I adjust my syllabus. And it's easy to just say, well, I'll just incorporate some more recent precedents into the syllabus, but keep basically the same tack, right? Keep the same learning objectives, keep the same overall message. And I feel like the practice of law looks different now. It will continue to evolve. It involves different frustrations and concerns. And I want to try to hear those and incorporate those into teaching as well. It's easier in a seminar sort of setting, I think, frankly, than say a survey where you're meant to sort of introduce the doctrine that is animal law, if it can be defined as any one thing. But if you're in a seminar sort of setting that invites student discussion, it's easier to do this. But I think the sort of degree and depth of change in the law matters a lot to students. And so those are some reasons why I think it's important to be mindful of it. And you asked, so I can open the floor just for everybody else. You asked also, Sol, how a little bit of how to incorporate it. And I'll just say one point that I wanted to get across tonight, and I might say more about it, is I've always in the past tried to make adjustments to what I will do in class on the front end. It's easier, coming into the semester to make adjustments to the syllabus, but once you get rolling, it's kind of also easy to get wedded to what your syllabus is. And I don't know that I do it super well. Isaac Soul could probably make some comments about that, but I like to think that I would open it up to student input during the class to sort of see what's of most concern to students, interest, frustration, whatever, and adjust a bit on the fly. I don't know that I'm very successful at that. I definitely make some effort at the beginning of the semester to address what I see as changes in the law relevant to animal protection and animal law practitioners. But I think it would be very wise to try to do it midstream during the semester as well in response to student input. Not sure how best to handle that. So,
Yeah. Oh, I'm sorry. Go ahead.
Okay, just real quick, I was gonna say, you know, while I'm teaching wildlife law or animal law, it's so rapidly changing and shifting. I might have um, a class on animal testing in a month, and given what's happening there right now, where does that land in 30 days? I mean, truly. So it's shifting so quickly. But I think it's important to stay on top of it. And why you should always look at where the law is going is because our students are, right? And they want to be learning the latest and greatest. I'll give a really quick example. In my class, we have a paper, and I had a student that was super interested in this Dallas-based biotechnology company called Colossal, and they were working to bring back the woolly mammoth by 2028. And when she brought this idea to my attention on a paper, I was like, okay, interesting. But I realized it was kind of my own bias, and it was one of a super cool paper. And then after she had finished it, I said, you really, and after the class was over, I said, you really should submit that to Law 360. And she ended up making some changes. She submitted it, and it actually got published. And so, staying on top of these topics, even though, sometimes it might be my own insecurity of not knowing everything that's happening so quickly, but learning from your own students, it's what they are chasing and what they're going after. So I just think it's so important to stay ahead of the times, because your students will definitely be there.
Yeah, I'm sorry, does somebody want to go? Um, I think I might have sort of a additional point of view on this, and this comes admittedly from my kind of activist bias. I always think of myself as like an activist in a lawyer costume, which I think honestly is sort of the core of animal law, right? Animal law is weird, and you have to love it, and you have to kind of lean into this. It's a feature and not a bug, right? Change is part of the law. If we think of ourselves as animal lawyers and as helping kind of change the mindset or the critical thinking or kind of click people as students into this topic, we have to understand the frustration that comes from feeling like you don't know what's going on because nobody really knows everything that's going on, right? But also, what is the role of an animal lawyer? And I think trying to break new ground is inherent to that role, right? None of us, I think, would say animal lawyers should just be repeating the same case within the same four corners of whatever we've already been doing, right? It's important to have understanding of legal research and writing, have fidelity with the law when you're, making your assessments and you're developing your strategies and your analysis. But at the end of the day, change is the fun part, right? I used to have these conversations when working with law students early on where regularly, I'd give an assignment and they'd come back and be like, well, there's nothing on this. And I'd have to be like, I know, that's why I'm asking you instead of looking it up, right? And I think it became very clear which students were like, oh, that's really cool. That's really cool that I get to sit here and think through these things. I mean, law is this exercise and analogy, right? Where can I pull things from other parts of the law and where can I start applying them to real world problems? And a lot of times animal cruelty issues or animal exploitation issues are, the best window in to really test whether the law is getting it right, right, and whether the law should be applied over to those things. So I think some of the process for teaching involves acknowledging some of this and giving the students a little bit of a chance to relax on having to feel like they have to know and memorize every single thing, and then that's sort of the job. And more about where should you be looking around? Check out what's going on, check out what's being tried. What was the story that led to it, right? Like one of the other hot cases that's being talked about a lot is that Dachshund case in New York about negligent infliction of emotional distress, allowing the dog to be considered a family member. Um, and people talk about what does that mean, and it's an interesting progress, right? But if you look at the story of the organizations that got involved and, kind of all these pieces that come together to be able to make an argument like that, right? That's fun. Now you're in it. Now you're an architect of this work, right? So to me, I think lean into the changing aspect of it, change the mindset a little bit, and you see some more engagement and creativity. And there will certainly be students who are like, I don't like this. Like, I need to be like a tax lawyer or something, right? Which is fine. We need tax lawyers, helping out animal law too. But like the animal law, the most interesting and, potentially high impact parts of it, there is not a well-worn path.
Yeah, going off of that last point by Professor Leahy of not having a well-worn path, how would you suggest for other adjunct professors to balance that teaching of the long-standing doctrinal law that according to that is according to animal law and the new developments? I know Ralph kind of touched on this a little bit and said that he kind of does it on the fly. Do you have any recommendations for professors in integrating it? And if so, do you think that there's any difference depending on the nature of the class, whether it's a seminar or whether it is a survey or an experiential class?
Happy to go first real quick. I think that, what I always try to do before I teach is go back and look and see what new cases have come out or if laws have changed on that particular subject. But one of the things I love to do, and I learned this from Kathy, is in the beginning of each class, I take about 5 to 10 minutes and talk about current topics because I think for all of our students, it's really I love seeing the light bulbs go off when you show them something that is happening right in front of them relating to wildlife law that happened 2 days ago. So, something that I looked at recently was Hawaii has a new bill that they are trying to give non-human rights to the coral reefs. And it's an awesome bill. And it just happened to coincide with my discussion of non-human rights in my class. And so it was so great for them to see. And that's a very dynamic and changing area, anyways. But to see, like, here's Hawaii trying to protect coral reefs in this certain way, and we're learning about it now. So sometimes we talk about current events as simple as an owl, a Eurasian owl that escaped a zoo, and now it's out in the, what do you guys think about this? Or all the eagle cams, or it might be something that a hunter just had a huge fine under the Lacey Act. So, I try to start my class with some things that are just completely new and maybe even changing laws here and there to get the discussions going, but always looking at, if I'm going to teach that day, what has changed since the last time I taught it.
I love that idea. I hadn't thought about that as an answer until Shelby just said it, but I love the idea of introducing sort of stuff in the news and then taking the discussion from there to something and having the responsibility as the professor, sort of the conductor in the discussion to make it relevant to learning objectives. That's our job, but to open it up to students to react to something that's very contemporary. That's a great idea. I've incorporated sort of hot topic sessions into my classes before. I know a friend who teaches at NYU has had students just sort of go out and find something happening to animals in the world, because there's usually always a legal element to it in some way, shape, or form, or could be, and having them just introduce that at the beginning of classes which could be a way to balance it. I do think that it may depend on the type of course you have as to how much balance you can provide. If it's intended to be an intro to animal law, you might need a bit more of the core longstanding doctrinal stuff in there. But you could still make it seem sort of relevant and fresh by introducing a sort of what's in the news type of thing. And it could be as simple as a story about what's happening to a particular owl or a tiger found in a bathtub in Houston or whatever. Or it could be a recent case. You could say, how does this CASA decision that just came down on nationwide injunctions, how do you imagine that might affect animal law practitioners or mission-driven advocates that are representing clients that are trying to make changes in the law that don't care about monetary damages, and they want their injunctions to have very broad effect and shut down, agency actions wherever they might be felt, even if you're challenging them in one particular jurisdiction on behalf of a few members or plaintiffs. So I think what's in the news could be very highly legalistic, or it could be very highly factual, and you could sprinkle that in, and that'd be a good idea. So now that Shelby said that, I've got some ideas for my next class about incorporating more in the news stuff as a way to keep it fresh.
I totally agree with both of those. I call it the "this just happened," which is a technique to kind of bring energy into a conversation. So it works anyway. But I think in addition, and it's not just like, oh, here's a case that was resolved. It's also like, here's a press conference that somebody in the movement is holding about something that, is going on with animals or whatever. And I think there's another element to this that can really be helpful, which is the sort of issue spotting aspect of it, right? I think if there is one thing I hope to get out of, whether I'm teaching a course or even if I'm just giving a talk, I hope to see that shift of people really engaging with the facts and then being able to come away with a new perspective on it, right? I think sometimes with things like investigations or, we don't have a lot of ways to get facts in our movement in a way that's really comprehensive. So, there's public records, there's whistleblowers, there's, investigations, there's some old school, research type tactics, things like that. So when we have that, it's generally like a pile of facts. Something just happened. What does this mean? Where did this come from? Right. And more often than not, there will be a lot of things that could be done with those facts that never come to fruition, right? All of us probably have a list of, these are some cases I could do that actually never turn into cases, right? So the exercise of being able to really engage with facts and say, oh, what about this, public health element of an investigation? Or what about this, type of cruelty that is different than what we've seen before? Or, does this whistleblower have this kind of protection or whatever, right? Is a different kind of, it's a really important exercise, I think. And it gives that kind of excitement of now I'm in the game. Now I'm, actually part of this. So I always feel like two things I watch for when, I'm teaching class, or like I said, even when I'm just giving a talk or something. But one is regularly, once people really get over the initial resistance to looking at graphic material, they'll say, I had no idea it was that bad. And honestly, I feel like if there's nothing else they take out of this going forward in life, like that should be it, right? I mean, that's the base that we base everything on, right? And yeah, because we've all been told by thousands of advertisements and people in our culture that it isn't that bad, but it is that bad, right? So we have this like really gold opportunity to be able to see a little bit of what's going on. The other thing that I notice quite a bit, which is subtle, but it happens, is in the beginning, people will say, you get them in that problem-solving mindset, right? And so people will say, well, what you could do is this, or have you tried this? And then there's like, maybe it's like class 3, it'll switch to, I think we should try this. Right? And it's subtle, but it's very important. And I think that's the difference between what I said. I say animal law is weird and you have to love it, right? And other types of law that, they're all being exposed to in all these different ways. So, it's like put yourself in there, jump into the game, like water's warm, come on in, we need you, right? And I think that exercise of being able to say, here's what's going on. It's messy, there's no clear path. That's a really important sort of teaching and engagement opportunity, in my opinion.
If I could just
I,
chime
I,
in. Oh,
sorry, go
sorry.
ahead, Isaac. Yeah,
I
go
just
for it.
wanted to share a little my student perspective on this. I totally agree with what's been said. Shelby, I think that my experience in those doctrinal classes has been that that like time at the beginning of class introducing like current events has been very effective in that format of getting exposure to like changes in the law. I think in a seminar setting, what I have really resonated with is opportunities to reflect on traditional cases or materials with like a lens of developing changes. Something that I really enjoyed in this practicum I was in last semester was reading these traditional animal law cases. And so I was both understanding kind of where animal law has been and where it's going, and then reflecting through a discussion on how might this be different under Loper, for instance? Like what kind, like would this be decided the same way? What kind of facts might have more or less weight? And I think that lens, as Cheryl kind of mentioned, it kind of really pulls you in as a student to be like, okay, well, now I'm part of this problem. Like, what can I do? What might be tweaked here? What kind of facts can we poke at to see if this is still going to be the case, or is this like an avenue to go forward in terms of like a student as an advocate, professor as an advocate?
I know that every animal law class is different, Isaac, and that you've had, I think, one, but I wonder your reaction to the sort of Cheryl's idea, and I'm paraphrasing and putting words in her mouth, but the sort of presenting the pile of facts and thinking back to Cheryl's earlier comment about making students feel like they're an architect of the law and the transition from what we're learning and then transitioning to the what we could do type of thing, feeling like they're part of the law. I wonder if would you have liked more of a sort of pile of facts, right? So here's like the past animal law case, and you might have had some discussion in seminar about like how might it have been decided different under newer precedents or whatever. Would you have would it have would it have helped you in terms of dealing with changes in the law or familiarity with that or preparedness for practice in it to have a bit more of piles of facts sort of exercises?
I think for me, because the animal law opportunities I've had are so limited, I think the mixture of the traditional law with the lens of like new changes was really effective because I felt like I was both able to learn and also be engaged in like and understanding the trajectory going forward. I think if I was in like a, animal law 2 class or like an upper division, like I was beyond this introductory course that I kind of view that as because it was my first one. I think I would enjoy that a lot. I think it would be very engaging for me. But I feel like, especially at the beginning of the semester, I felt very much like this is what I really want to do, but I know so little. And so I was really interested to just engage with the traditional materials at the start.
Yeah, I really agree with everything Isaac said. Obviously, I took the same class as him, so I have similar experience, but I really am glad that you spoke about, then applying that new precedent to the doctrinal cases that we read, because that is so effective to be like, well, what would you do as a lawyer today in the same case, right? Like, how would you view it any differently? What new tools can we bring in that maybe people weren't didn't think of it at that time, or now knowing what we know and how the court reacted, how would we move forward with this? I also thought it was great in the class to think of extra legal ways to kind of go about it, right? So kind of being like litigation maybe wasn't the best remedy for this, wasn't the best avenue to kind of pursue this. We can maybe, think of this in a policy perspective and in another type of, advocacy perspective that maybe isn't exactly perfectly nestled in a courtroom, but can be maybe adjudicated parallel to that to help aid in it, or maybe I think another great thing was thinking strategically, like, animal law is a lot about building blocks and building bricks to the wall. It's not necessarily that you're going to go into litigation and then change the entire landscape of everything. So kind of being strategic on, well, was this the right case to bring? And I think Professor Henry was really good and kind of asking those questions and kind of thinking strategically in a way that you have to in animal law that you may not have to in other traditional doctrinal courses. Like, was this case the right case to bring with this plaintiff in order to advance hens that aren't being in battery cages anymore, or whatever it may be. So I'm really glad you brought that up, Isaac, and kind of sticking to you for a second, and speaking on students' perspective and their preparedness for class and everything. Would you, and then of course the professors as well can opine, what would you say are some classes that perhaps professors should recommend or suggest that students take prior to taking an animal law class? Do you think that certain parts of your background before you took the class were extremely useful in particular, in kind of grasping the material a little easier?
Yeah, I think admin law obviously very important. I think I didn't quite grasp that before I came to law school. I really enjoyed admin law, but I know it's a big hurdle for a lot of my peers. And I think that I really came into an understanding of how the law actually operates in like this multimodal sense, as you kind of mentioned just barely, Sol, about policy versus litigation. There's like kind of there's lots of components to this, and they don't always have to be settled in a courtroom or through litigation. And I think overall, I think I find it very effective when change is candidly discussed with students. I felt, especially during 1L, like this kind of attitude of avoiding like current changes because professors are like, oh, well, they're never going to strike down Chevron. They're never going to do this. I felt like that was very frustrating because I felt like talked down to in a way because I'm like, I'm stressed about this. As kind of Ralph teed up earlier, I was like, this is something that I think could happen. Like I've seen what happened with Sackett as I came into law school. I saw all these other things that are just kind of upending what I expected to be learning in law school. And so I think it makes me feel much more engaged when professors are candid about changes in the law. But in terms of courses, I think really admin was pivotal to like my law school experience and my legal education. And I think that is like the far and away the most valuable course I've taken in law school.
Do any professors have any thoughts on what they think would be a great background for students to have going into these classes?
I think it might depend on the nature of the animal law course. And I always struggled with when asked by administration folks whether we should have prerequisites for any particular animal law course. And I've taught different ones, experiential ones, seminars, what we should have as prerequisites. I never really landed on any as a required thing. Occasionally admin as a suggested, but I've had students come out of animal law thinking I want to dive more into remedies, for instance, or courses that cause me to policy oriented courses that cause me to think about um, ways to lawyer in non-traditional ways to lawyer, because the animal law courses I've taught, whether they've been introductions to animal law or experiential courses about practice of animal law, have all been about animal protection law and advocacy in sort of a mission driven policy change setting. And for that reason, if that's the sort of animal law you're teaching, if it's not contracts and animal law, racehorse stud books, like animal industry types of things, which I know could be a different, could be part of the core concepts in other animal law courses. I suppose that it would help to sort of think about public interest litigation and lawyering and policy change and have courses in those. But I think it really depends on the course and the learning objectives, because any animal law course could be structured in many different ways. A lot of it is in most law schools, the animal law course is an introduction to animal law and animal protection, and is maybe the only course on animal protection oriented themes that students could take. But students take it and go on to practice other things, and they can take a lot of learning away from the animal law course, even if they don't end up animal law practitioners. And so I think it's really important to signal in your syllabus what your learning objectives are, and then the best courses to prepare for it sort of fall out from that, in my view.
Yeah, I would just add to that, my perspective is it's animal law touches on every single topic, right? Whether it's First Amendment or constitutional with the Shack 7 and US v. Fulmer, whether it's a really bad adoption contract that I like to go over in detail. It really touches on every single aspect of law. And again, seeing the students be like, oh yeah, this definitely could deal with property. Whether it's again any kind of animal protection laws that we talk about, it always gets into criminal law. So, I always tell people really my class is an introduction to those other classes if you haven't taken them through the eyes of animal law or wildlife law. So I do agree though with Isaac that having administrative law would definitely be helpful, at least for my wildlife class. But everything else truly can touch on every single aspect of law. And that's the exciting part because a lot of my students, SMU is in Texas, and obviously we have kids from everywhere. But really, from our perspective, if you have some students that are going to go back and just be the family lawyer in maybe their towns or, work on their family estates, whatever, I try to give that at least touch of every single aspect to each class.
Great. I think we have time for one more question, and then I will open it up to see what the audience would like to discuss in a little more detail. So keeping in mind how many things we've talked about, facts and dumping and doing the news at the beginning of the class and all these different, adjudications happening all at once, what are the best resources that you recommend for professors and for students to kind of keep up to date with everything changing so rapidly in the animal law world?
Well, this is where I get to plug the Brooks Institute resources. For anyone who has not subscribed to the digest, that is exactly meant to answer this question. That's, cases, important things that are going on in animal law policy. There's also a newer, less frequent digest on scholarship that touches on animal law from different disciplines, academic disciplines. And then, as I mentioned earlier, this ALPA program, which is focused on practitioners, as soon as people are licensed lawyers in the US, can become a member, and very detailed written resources and networking, co-counsel, mentorship opportunities. We're going to have a forum where people can, real time talk to each other, let people know what's going on. I will say, I think it's important, as I was in the process of working on this program and, talking internally with the team and trying to figure out what was really the gaps we were trying to fill. I talked to a lot of people, and a lot of people who are just getting new to animal law, or even students or just getting out of school, and people who have practiced animal law for a long time. And nearly every single person said a version of, I feel isolated. I don't feel like I'm on top of everything. I don't feel like I really have peers who I can bounce ideas off of, who understand what's going on. So, it's great when we can all get together and talk about stuff, but I think take advantage of, get yourself a community, take advantage of that. I mean, there's others, this webinar series, for example, is a great kind of community to bounce ideas. There's, the ABA tips community, et cetera. There's other things going on. But, ALPA is meant to be a place to really just give those resources and dedicate that, because that isolation, I think, is what leaves a lot of cool ideas just sort of on, the floor or whatever. And so I think don't feel like, as a student, as an instructor, as a practitioner, right, that you're alone in your isolation. I guess that's sort of an ironic way to put it. I think it's pretty important to, just sort of keep up with your community.
All right. Well, feel free to drop the link for that in the chat if you'd like. And I'm sorry, Shelby, do you want to jump in?
I was just going to give a shout out to Brooks Institute. They're the best. They're the gold star. Be wary of certain websites that they post laws and cases, and sometimes they're not always accurate. So I love Brooks.
And a lot of the resources, Brooks is great. look at the digest. I was looking at the digest that I didn't get to from last week earlier today. Um, but a lot of the animal focused resources are going to report on cases, laws, developments that are very specific to animals. And yet, a lot of times we want to teach the law that's changing that will affect animals and affect animal law practitioners that might not come up with, in even the Brooks Digest or even, you know, um, uh, other specific animal law journals. You could go to Lexicology or Westlaw Alerts or Google Scholar and type in animal law terms, and you're not going to get the stuff on standing necessarily, or injunctive relief, or limitations periods for bringing actions against agencies or whatever. And so I think that branching out and creating a community around yourself of people who are practicing it, people who are teaching it. Part of the reason why I'm part of this group that we have, that we're doing these webinars, is as much as an audience member and connecting with people, so that I could always email Cheryl or Shelby or Conley, or Rebecca, or Nancy, or all of the other members and say, what are you teaching? What's different? What are you incorporating? I think that's super helpful. So I just want to echo Cheryl's comment on creating community. It's important for practitioners, and Brooks is a leader in that right now, but it's also important for teachers.
Fantastic. And just for the recording purposes, I'm not sure the chat gets transcribed. So Brooks Institute, Brooks, will be linked in the chat, and hopefully you check them out. But I definitely want to open the floor to some questions for the final few minutes. If anyone would like to either use the raise hand function, come off mute, or put a question in the chat, please feel free to do so. Just give it a minute. Yes, Kathy.
Thanks. And I don't want to take up too much time, but I'm really interested in Saul and Isaac's perspective about whether there's more that we can do as faculty members to deal with the anxiety of the changing law. Because what I've noticed with my students is in the spring, there was heavy anxiety, right? The students were like, I don't know what's going on. Like, I literally don't know where the law is going. I don't know what's happening in the Supreme Court. I don't know, the stuff I'm learning in school isn't relevant, right? Isn't correct any longer, or might not be correct in a few months. And so there was heavy anxiety. And then it's sort of adjusted in the fall, with some students more anxious than others. And now students seem to be in this sort of dissonance. Like, today we're just going to pretend that the law is what it's supposed to be, what we think it's supposed to be, and we're going to ignore some of the stuff that either enforcement's happening through administrative agencies, or with what, the district courts are very different right now than the Supreme Court. And so some days we're going to just pretend like it's normal. It's like what it would have been a year or so ago. And then other days we're going to dig into that dissonance. And other days we're like, it's just changing, and we have to accept the fact that it's changing. So I've seen students kind of all over about that. And so this is not just animal law, but obviously it affects our conversations about animal law. So is there anything that you guys want to share about that, or things that we as faculty can do to support you in experiencing those realities?
I think for me, as I mentioned earlier, I think a big part is just being candid that the law is changing. As I mentioned, it's very frustrating to have these anxieties and then to go to class and have the professor, not engage with it at all, not reference it. I think it's very validating to hear that, yes, the law is changing. We're still figuring out what's going on. Um, but for now, we're going to teach the class. And I think a lot of that dissonance comes from just the structure of law school. So much of it is just, I just want to get through the class. I want to take the exam. I want to get my grade and move on. And you're not really able in these doctrinal, especially doctrinal settings, to really engage with those changes in a way that is meaningful, or you're able to reconcile those like anxious feelings. But I think being candid about it, I feel maybe less nervous than some of my peers, because I have felt for a long time that the law is very indeterminate and there's like very subject to whims of various decision makers. I came into law school on the heels of Dobbs and Sackett. I very much have seen like the impact and like negative feelings that spring from these decisions, and I have accepted a long time ago that sometimes the law is just what the people in power decide that it's going to be at any given time. And so I can, for me, I've been able to kind of come to terms with the fact that the law is variable, and I think being candid about that to students can help them come to that similar place of semi-peace.
I completely agree with Isaac on all points, especially being candid. And I think to the point of, different classes, doctrinal or experiential, I think it is important for my professor to push back a little bit and be like, well, if the law changes tomorrow, how does this rule? What are, for example, we've talked about the benefits of Loper Bright being overturned because although so many people are panicking over that, there are actually some upsides for animal law that we've discussed, that there are new avenues for opportunities and litigation that perhaps weren't there 4 or 5 years ago, and new kind of communities that we and advocates that can be called upon at that time. I also think that because of how unstable it's mostly the federal government right now, that is, I think it's been really nice to get a state perspective in the animal law class and kind of highlight the federalism and how that plays a huge role. Professor Henry, I don't know if you want to elaborate a little bit on this, but I know in our class we discussed a lot of, well, the state courts are the ones really doing a lot of the animal law enforcement in a lot of cases, especially concerning animal welfare. And, that has a whole different ballgame almost than the federal courts. And so that's something for students to keep in mind, especially when so many doctrinal classes tend to be appellate cases and more geared towards federal law and federal courts.
Yeah, for fear of getting too granular, I won't elaborate, but I'll echo the sentiments that I think it's important to be candid, to come across as credible, so that you can be in conversation with students where they're at, and to recognize elements that are positive, that students can take to inform their education and their practice so that they're continue to be excited about what lays in front of them and motivated if you can. I think that's part of our job. I got some feedback from students this year. I wish we would get more. It's great. It's anonymous, so I don't know who said everything. And I'm paraphrasing, but one of the things I took away from feedback I had this year was that at least one student felt it would be helpful to be even more open-ended in questions. I'm better now than I was 15 years ago about not being a lecturer or anything like that, but to be open-ended in questions and signal, greater flexibility for conversation. And I think one of the benefits of that is opening up a class to being more honest and transparent about changes in the law and allowing students to engage it. And so that's something that I will attempt to do moving forward, is creating more space for conversation wherever it goes.
Any last thoughts? Okay, great. Well, thank you so much, everyone, for tuning into this webinar. Like I mentioned at the beginning, we will have one last webinar in March, so please stay tuned for that. But I want to give a huge thank you to the panelists. Thank you so much for your insights. And if you are interested in being a panelist or joining and putting in a discussion that the GW Animal Law webinar should have, please feel free to reach out for that as well. And again, these recordings will be available shortly online and on the YouTube channel for GW Law. So thank you again so much, everyone, and I hope you have a great night.